Hi, my name's Wade Poziomka, and I'm a partner at Ross McBride in the Human Rights and Employment Group. Today I want to talk to you about entitlements in Ontario when you're terminated. When an employee is terminated in Ontario, there's two baskets of entitlement. The first is the Employment Standards Act. This is a piece of legislation that sets out the minimum entitlement an employer must pay to an employee. In other words, this is the floor with respect to entitlement, and it can be quite low. The second basket of entitlement is called the common law. When looking at an employee's entitlement under the common law, we look at what courts have given to employees in similar situations in the past. Similar in terms of a number of factors, but really a few key driving factors. The employee's age, level of position, and length of employment. So for how long the employee's worked for. Let me highlight the difference between the ESA minimums and the common law with an example. John works for a relatively small manufacturing shop in Hamilton, ABC Corp. ABC Corp has 10 employees. John's worked for ABC Corp for 25 years. However, recently, ABC Corp scaled back their operations and let John and two other employees go. John's 58 years of age. John's entitlement under the Employment Standards Act, or his minimum entitlement, is 8 weeks of termination pay. At common law, John would be entitled to 78 to 86 weeks, or 18 to 20 months. That's quite the difference. 8 weeks on the one hand and 20 months on the other. Employers can limit employees in Ontario to the ESA minimums if they do so properly in an employment agreement. Often, however, contracts that try to limit an employee to the ESA minimums don't do so properly and are unenforceable, meaning that the employee is entitled to common law. This would be good news for John, as an 8-week entitlement could be up to 20 months. Now let's assume that the provision in John's employment agreement fails, so he's entitled to common law notice. Just because John's common law notice period is 20 months doesn't mean that he's entitled to 20 months. There's an obligation for John to go out and look for new work. This is called the duty to mitigate. Let's say that John goes out and looks for new work and finds a similar job paying the same as he was making at ABC Corp after 13 months. Even though his notice period is 20 months, he mitigated his loss after 13 months, so ABC Corp may only have to pay John 13 months, not the remaining 7 months in the 20-month period. The John example really highlights the importance of seeking legal advice when you're terminated. If John just assumed he was only entitled to 8 weeks because employment contract said so, and he didn't obtain legal advice, he would have possibly left 18 months' pay on the table he may have otherwise been entitled to. In the event that you're terminated, it's very important to have an employment lawyer review your agreement. People without legal training often don't know what they're entitled to, and what the employment agreement says is often different than that entitlement. In the event that you're terminated and you need to have your contract reviewed, feel free to reach out.